Okay, guys, let's get going here. The chair has to deal with it. She's got a personal issue she's got to deal with. She may be back, but let's get started in the meantime. So we're going to start with Senate Bill 112, but bottom line is I have an amendment, and I know Senator Jennings has some amendments, and so this is going to actually take a while, this bill. So I think in lieu of taking up all the time, I'm going to ask that we hold this particular bill for our next session, because I think, again, it's going to take some discussion. So let's go to the next bill, which is, Senate Bill 112 we're going to hold. So let's go to Senate Bill 570. Patrick, why don't you describe the bill? And take it from there.
So Senate Bill 570 is an administration bill that adds the 2019 novel coronavirus, or COVID-19, to the list of contagious diseases or viruses, to which an exposure requires a notification by a medical care facility that diagnoses the disease, that goes to certain emergency services and public safety personnel. Under current law, a medical care facility that diagnoses a contagious disease or virus has to notify these frontline personnel who were in contact with the patient of possible exposure to the disease or virus. The bill also allows medical care facilities that must make the required notification to enter into an agreement with the state-designated health information exchange to facilitate the required notification.
Okay, are there any amendments or any kind of reprints? Okay, so the bill is in front of us clean. Are there any discussion? Questions for council? Okay, Senator Hayes. Okay, we've got a motion favorable from Senator Hayes. Is there a second? Senator Hershey, second. Okay, all in favor, raise your hand. All opposed? Anybody opposed? Okay, I think we have a unanimous vote on Senate Bill 570. We're going to next move to Senate Bill 204, Senator Bottle, and that's David.
Pardon me. We're actually we're going to address Senate Bill 52 first.
Okay. Let's go on the list to Senate Bill 52.
It's actually not on the list
Okay.
at all. This was the bill that was passed by the committee and then recommitted this morning. So there's a reprint.
Oh, right. Okay. Everybody knows the bill we're talking about. Chair Kelly's bill that we recommitted this morning. Yes. Go on, Nathan.
Senate Bill 52, it's sponsored by Senator Washington, and the chair moved this morning to recommit it to the committee. There's a reprint in the pile to the right. There's a stack of papers on the right side of your desk. It's in and among there. Senate Bill 52. The reprint before you reflects an amendment that strikes the preamble, and that's the only change.
Okay, so that's the amendment on the table. Is everything in the bill stays intact except for the preamble? Any discussion? Okay. Senator Augustine, you have a question? Yes, you want to discuss?
Why? Why would we do that?
Well, who proffered the amendment? Was Senator Chair Kelly or Senator Jennings? Okay. Senator Jennings, you proffered the amendment. Time for discussion of the amendment.
It was just discussion amongst other members on the floor and others that, there's issues in the preamble that we never discussed, we didn't talk about. We just wanted to focus on the actual bill and what it's focused on doing, and just remove the preamble. That's really what it is.
Let me just get Chair Kelly. Chair Kelly, we're on Senate Bill 52, which was the bill that we recommitted today. That Senator Jennings has offered an amendment to deal with the preamble, so we're just started to discuss it. Senator Augustine wanted to discuss that amendment, so why don't I'll hand it back to you to talk about the preamble. That we haven't done anything.
Finish up with
Okay, well, so we have a discussion. I think Senator Jennings made his point about preambles. I mean, the one thing I would say is there's always been a discussion about whether any of the bills in the Senate should have preambles or whereas clauses, but that's not a policy or anything like that. It's really doesn't go to what the bill does, but that's just kind of an observation. Any other discussion? We have an amendment. It hasn't been seconded. Has it been seconded? Okay, so further discussion. Senator Augustine, you've got the floor if you want to.
Well, I'm just not understanding. This preamble was here. We all already voted for this, right? I mean, wasn't that the case? And what changed? Yeah, you can help me out. I just understand.
I think the concern that the minority party is raising, and it was raised on the floor of the Senate, and so we brought the bill back. And since I think the vice chair is right, we don't really have a policy on preambles and all this kind of stuff. But if we'd like to see our colleagues' bill go through and not take up an inordinate amount of time on the floor, and the bill, what the bill does is still going to happen. With or without the preamble. And so I would say that when you consider all that we've got to be responsible for this bill and many others that are in the queue waiting, I would just say that if you don't have an earth-shaking reason, we'd like to get this bill back on the floor and get this voted and through and to move other bills.
Okay, well, any further discussion on the amendment? Senator Hayes.
Yeah, I mean, I agree with what the chair is saying for the sake of time and to get to the issue at hand. I think it is, for me at least, and I can only speak for me, and to Senator Jennings' credit, I think he raised this issue with me as we were going to the floor, but this country does have the issue of racism, right? And, you know, and it's taken a long time for us to acknowledge that just by striking the preamble. I don't think that erased the history, but I think the drafter at least acknowledged that the reason why we need this bill is to acknowledge the inequities as it relates to the application of health in our society. And so I get it for the sake of, you know, moving the bill along. I'm not sure if I'd be in a position to cast a vote to say, no, we should strike history. But I think the bill is good, and that's why we all voted on it as a committee. But I definitely honor the chair's, you know, need, as I do. I think we've been held up on numerous occasions by, you know, over discussing things that probably shouldn't. But I just wouldn't feel comfortable, you know, casting a vote to erase a history that we all know pretty well here in our country. So.
The only concern, I guess, I meant now that, you know, Senator Hayes and Augustine, is if we're forced to do some kind of a roll call vote on a preamble, I mean, I think it's a very awkward, so just from a process standpoint, I do have to just put that out there. I mean, for the reasons you both mentioned, it's kind of like if we're not going to have some kind of unified position, then I think it becomes a little bit complicated to explain on the floor about an amendment. You know, I'm just being honest with you. I don't know how to resolve that. I just have to express that.
And that's not my desire either, to spot anybody on this vote. And so I would not ask for a roll call, and if we don't have to do one, that's fine. But if it was a roll call, I wouldn't feel comfortable voting against something like that.
I mean, another option that was discussed on the floor was that the senator could just offer an amendment, and the chair, as the floor leader, which you are, you know, could accept it as a friendly amendment. I mean, it doesn't. I mean, I don't know what the advantage of having a long discussion and vote and all that here, but that's just, again, maybe an option. I don't know. Just trying to figure out a way to. Madam Chair, any thoughts on? Okay, yes, sir. Senator Hershey.
Thank you, and I appreciate the comments of both of my colleagues, and obviously we did vote this out the way that it is right now. There was concerns about some of the specifics in the clauses. I don't want to go into what they were, but it just made some members feel a little bit uncomfortable about voting for the entire bill with all of those comments. This is not meant to erase history or to not acknowledge that these conditions aren't out there. It's just, do they need to be in writing, in uncodified language, in a bill that we've all supported, and I believe that we all are going to support on the floor. This was just a request that our caucus made to say, can we find a way to take it out, bring it back to the floor, we'll all vote in favor of it, and we'll be done with it. So that's it.
I will say this. I did let the senator whose bill it is know that the reason I was standing to ask that it be brought back was because this had arisen as an issue, and that it was not at all with the content and the output from her bill. And I wanted her to be aware of that so she wouldn't get upset on the floor wondering why we would bring the bill to the floor in order to recommit it or something.
And so my only question is procedurally, is there a way to proceed with this amendment without a roll call vote?
Well,
Do we have to vote for the amendment? Can we just go favorable as amended?
Or is somebody making a motion?
I'd make a motion that we vote favorable as this bill is amended in front of us.
Okay.
Okay, so we've got a favorable as amended, the reprint is the document in front of us. I guess we'll take a vote on the reprint that's in front of us. So all in favor of the bill reprint, the favorable as amended in the document in front of us. Yes, Senator Bottle.
I just have a process question. Do we have to reconsider the vote that we made previously? No? Okay.
Because it wasn't about
Just process.
the substance of the bill at all.
Okay.
Yeah, okay, so that's the question on the table. A vote favorable as amended with the reprint in front of us. All in favor, say aye. Okay, all opposed? Okay, the bill carries. Madam Chair, do you want to, is anybody opposed to the favorable reprint? Okay, seeing none, unanimous vote. Madam Chair? Thank you, Madam Chair.
All right, and
do you want
thank you very much.
Do you want to go next? The next bill, we're on the, we're going to Senate Bill 204, Senator Bottle's next on the list.
Okay. Go ahead.
Okay, Senate Bill 204, Senator Bottle. Dave, you want to explain the bill?
Okay, Senate Bill 204 requires the Maryland Department of Health to adopt regulations regarding the development of memory regulations for memory care and Alzheimer's disease units in assisted living programs. The sponsor has offered amendments to the bill, which changed a lot of the bill. So rather than just describing the bill as introduced, I'll just go to the reprint you have in front of you for Senate Bill 204. So first off, there's a definition struck on page 2 of the reprint for limited nursing services. And only one definition is left in the bill, and this is for direct care staff. And instead of having a lot of regulations required to be adopted, the bill is streamlined and requires regulations relating to training for dementia specific training that is required to be completed annually by administrators and direct care staff assigned to a special care unit in an assisted living program, and a direct care staff ratio adequate to meet the needs of residents. Then if you go to the very last page of the reprint, there's been regulations under consideration by the Department of Health since at least 2015 for assisted living programs. So there's uncodified language added that would require that the department adopt these regulations that have been in draft form on their webpage since 2015 by December 1st, 2022, and that these regulations include the regulations under the bill as amended.
Okay, does anybody want, any questions for council on what's in the reprint before we?
I just want to ask Senator Bidle, does this go along with the lines that they said that there was going to be, like the department was supposed to be doing some regulations and they hadn't done them?
They have proposed regulations, as council said, that have been on the website since 2015 or 2016, that they've never completed. So instead of trying to pull the memory care out of those regulations and do it separately, this just says, get the regulations done. You've been sitting on them for 5 or 6 years. We need to get the regulations completed. So it gives them a year to complete it.
A year? Okay, do you think that's enough time with the COVID, all the COVID stuff?
I have heard from other people that Dr. Ney at the Office of Healthcare Quality says that these are just about ready to go and they can be done.
Okay.
I have one question for council. I thought we took out the word ratio. Let's see.
Well,
And I'm trying to see where I saw it again.
direct care staff ratio adequate to meet the needs of the residents.
Yeah,
I thought, we thought you wanted to leave that in there.
No, just ratio. Just take out the word ratio. They
A
really
direct
put-
care staff adequate, oh, I see, okay.
Yeah, if you don't mind. So
No,
that's
no,
just
not at all.
A little short.
Okay, we can
amendment.
make a manual adjustment to that.
Yeah.
Just
You know,
So-
if you remember, there was quite a bit of pushback from Leading Edge and Lifespan, and so we're trying to accommodate their concerns, but still get these regulations done, because they really are very good, the ones that are online, and we just want to make sure that those couple little issues are addressed.
And those are the basic things that are getting done, what's online?
Yes,
Yeah.
it's online. You can
Did you
can
add
look it up.
anything else?
No?
No?
Okay, Senator, do you want to move the amendments with that one manual change of the word ratio taken
I'll
out?
move the amendments.
Okay, is there a second on the amendments? Okay, where's my second? Senator Klausmeyer, second, okay. All in favor of the amendments? Oh, I thought, okay, Senator Kelly seconded it. So we've got the amendments on the table. All in favor of the amendments proffered that are in the reprint, raise your hand. All opposed? Senator Benson, are you in favor of the amendments? You didn't raise your hand either way. Okay. Unanimous vote on the amendment. Anybody want to move favorable on the bill as amended?
I'll move favorable on the bill as amended.
Okay, we got Senator Bottle, Senator Kelly. I think we can just do a raise of hands on this one unless further any discussion about the bill before we take a vote. Okay, we've got a favorable motion on the table. All in favor, raise your hand. All opposed? Okay, I think we got a unanimous vote on Senate Bill 204. We're next going to move to Senate Bill 499. Senator Lamb, David?
This was heard last week, and this repeals the ban on selling over-the-counter medications in vending machines. The House bill's already in the Finance Committee, and it's a pretty simple bill, and all it does is under current law, you cannot sell or distribute or dispose of any drug medicine in a vending machine. Separate provisions say that you already can't do this with controlled dangerous substances or any other type of or medication requires a prescription or is required to be behind the desks by federal law. So this would just say that you could now, if you enact this bill, sell over-the-counter medications in vending machines.
Are there any amendments?
No amendment.
Okay, so the bill's clean in front of us. Any discussion before we entertain motions? Okay, is there a motion? Okay, Senator Kelly moves favorable on the bill, on Senate Bill, second from Senator Klausmeyer. We're on Senate Bill 499, favorable motion. All in favor, raise your hand. Or do we want discussion? I don't see, okay, all in favor of Senate Bill 499. It's a clean bill, there's no amendments. Everybody, either raise your hand or don't raise your hand. Senator Hershey, are you? Okay, I see a unanimous vote. Okay, that Senate Bill 499 passes unanimously. We're going to go to Senator Kelly's bill, Senate Bill 507. David, why don't you tell us what the bill does?
Okay, this bill requires an assisted living program, which has been appointed as a representative payee to report that information, to report specified information to the Office of the Attorney General's Consumer Protection Division. This information includes Social Security benefits by residents of the assisted living program during the immediate preceding year, and any other benefits received by that resident during the preceding year. There's some amendments. There's also a OHC, the Office of Healthcare Quality must refer certain violations of the consumer protection or under consumer protection law if they find them to the OAG. There's a reprint in front of you, and there's some amendments offered to the bill by the sponsor, Senator Kelly. These require that the Office of Healthcare Quality also notify the Division of an Assisted Living Program as a resident's representative payee at the request of the resident within a reasonable time after being made aware of the appointment. And then on page 3, there's clarifying language that specifies that OHCQ must, if there's an allegation of unfair, abusive, or deceptive trade practice, they should notify the Office of the Inspector General, or the Office of the Consumer Protection, as well as the Office of the Inspector General in the Health Department. This bill is also moving through the House right now.
Okay. Senator Kelly, do you want to move your amendments to your bill? Okay. Chair Kelly has moved her amendments, sponsor amendments to Senate Bill 502. We have a second from Senator Bottle. All in favor of the sponsor amendments, raise your hand. Okay, all opposed? Okay, the amendment carries. Any motion, Madam Chair, on your bill as amended? Move favorable. We have a motion and a second from Senator Klaus. Bill on the table, Senate Bill 507, favorable motion. Do you have you're premature there. Okay, all in favor? Say aye. All opposed? Bill passes. We're going to go to next bill, Senator Eckert's bill, Senate Bill 542. David?
Yes. If you recall last year, you passed, part of the emergency bill you passed for governor's powers gave nurses in state health care facilities the ability to work 12-hour shifts similar to the shifts that nurses work in private sector facilities. This would make that permanent. So this bill would authorize nurses in state health care facilities to work series of 12-hour shifts rather than 40 hours a week. They would be on par with nurses in the private sector. The bill, there's several amendments offered to conform state law to this new practice for these nurses to allow them to work 12-hour shifts rather than 40 hours a week. So the amendments I would consider technical to make state law, state personnel law and health department law recognize these new shifts for these nurses.
Okay, Senator Hayes, you have a question or you want to discuss?
Yeah, David, are we in receipt of the amendments that the House passed this morning?
These are I've had several amendments on this one. These are the latest amendments that the House is going to consider in subcommittee either today or tomorrow.
Yeah, I know they took a vote today.
Yeah, so these are there's been 3 sets of amendments. They keep coming back with tweaks to this. These are the amendments that the House supposedly is voting on in subcommittee today.
Okay, all right, thank you.
So the bills, if you adopt this, and based on what the House subcommittee did, these bills should be identical.
Okay, any further discussion about the amendments? Okay, Senator Kelly has moved the amendment. Senator Hayes, do you want to second it? Okay, we got a motion and a second. All in favor of the amendments to the bill, raise your hand. All opposed? The amendment carries. Anybody want to make a motion favorable? Okay, Senator Kramer, move favorable. Is there a second? Senator Benson. Okay, in front of the body, in front of the committee, Senate Bill 542, a favorable motion as amended. All in favor, say aye. Everybody, everybody, I'm going to wait until everybody puts their, okay. Hershey, is that a hand up or, okay. Anybody opposed to the bill? Okay, seeing none. Senate Bill 542 carries. We will now move to the next page. Also, this is going to be Nathan's portfolio. We're going to go to Senate Bill 153. Nathan?
Senate Bill 153 limits the annual Tier 1 percentage requirements under the RPS for municipal electric utilities. The bill subjects municipal utilities to requirements that are similar to those in effect for cooperatives. For context, the 5 municipal utilities in the state provide approximately 1% of annual electricity sales, and that's according to MEA. There are no amendments, and has passed the House.
Okay, any discussion about Senate Bill 153? Senator Hershey?
Get on as a co-sponsor, please.
Renewable energy bill, you want to be on it?
I need one.
Okay. Anybody else want to be on this bill other than Senator Hershey?
I may have to reconsider my position on this.
Okay. Senator Hershey, Senator Jennings, I think want to be on this bill. Okay, we've got the 2 new co-sponsors with that on there. Do we have a favorable motion, Senator Hershey?
Favorable.
Is there a second, Senator Jennings? Okay.
I think Senator Hershey takes it to the floor.
Okay, Senate Bill 153 is in front of us with the 2 sponsor amendments. All in favor, raise your hand. All opposed? Unanimous. Next bill, Senate Bill 168. Nathan?
Senate Bill 168 establishes the Maryland Suicide Fatality Review Committee to identify and address the factors contributing to suicide deaths and to facilitate system changes to prevent suicide deaths. You have a reprint of the bill that incorporates 2 changes requested by the sponsor. On page 4, the amendment removes members of the General Assembly from the list of individuals that the Secretary of Health may include on the state team. And second, the amendments adjust how the committee coordinates its activities with other fatality review teams in order to ensure efficiency in the work of all the teams. The amendments address concerns that were raised at the hearing.
Okay, any discussion about this bill? Anybody want to move the amendments? Okay, Senator Hayes.
Yeah, Nathan, can you, where does it explain how they will interact with the other review committees?
So that's on page 8 of 12 under D2. Instead of interact and collaborate, the team is now required to coordinate, and it further specifies that the purpose of the coordination is to ensure efficiency in the work of the teams. There was some concern that between the Suicide Review Commission and the Child Fatality Review Commission that there may be duplication of efforts.
Right.
This amendment would address that.
Well, that was my concern too, and that's why I wanted to see it, and I think this meets my, I've served on a Child Fatality Review Committee for 5 years, and so they do a lot of good work, a lot of expert opinion going to that, and I just wanted to make sure that there was no duplication of efforts, but I like this amendment. Thank you for pointing that out.
Madam Chair, one thing I just, if we're going to be somewhat consistent, it was brought to my attention, this is another bill with a bunch of whereas clauses. I don't know if we want to be intellectually consistent, having one bill that we say we don't like whereas clauses and another bill. That's, what do you think?
He said there is no policy on it. And rather than to start this now in the middle of the session, I'd say unless somebody objects, I'd leave it alone. And
Okay, unless somebody raises some issue, let's leave it in here. Okay, anybody want to, any other questions about the amendments or anything else, whereas clauses? On the amendments, so on the table or the amendments favorable, all in favor, say aye. All opposed, the amendments carry. Anybody want to move favorable as amended? Senator Hayes, Senator Augustine, second. All in favor of the Senate Bill 168 as amended, raise your hand. All, Senator Beidle, are you, yes? Yes, okay. Anybody opposed? Bill carries unanimously. Move to the next bill, Senators Kagan and Riley, Senate Bill 185.
Senate Bill 185 requires financial institutions to allow a customer to choose from at least 2 security questions for each security question required for the provision of an account. The bill applies only prospectively. There was no opposition. The cross-file has passed the House.
Any amendments? Okay, so the bill is clean in front of us. Any discussion? Senator Kelly moves favorable. Any seconds? Second, Senator Augustine. Okay, Senate Bill 185, favorable motion on the table. All in favor of Senate Bill 185, raise your hand. All opposed? Seeing none, unanimous passage of Senate Bill 185. Next bill, Chair Kelly's bill, Senate Bill 428.
I could just say something, 428, 429, and 430 are all here at the request of the Public Service Commission, and they just clean up just regulations that are messy.
Can we vote on the block?
Okay, who would like to vote these three as a consent calendar? Anybody want to pull anything off of the consent calendar? Seeing none, okay, so we have a consent calendar made up of Senate Bills 428, 429, and 430. Any discussion about the consent calendar, any of the bills therein? Seeing none, all in favor of the consent calendar items, raise your hand. All opposed? The three bills pass unanimously. Next bill, Senate Bill 47, Senator Quarterman. Back to David.
Okay, Senate Bill 47 was heard back in January and requires nursing homes and assisted living programs to develop procedures allowing for indoor visits to residents from essential caregivers. Essential caregiver is defined in the bill as an individual designated by the patient or resident of a nursing home or assisted living program to advocate or provide additional personalized care for the patient. The bill goes on to list the items that must be in these procedures on page 3 of the bill, and there are also some requirements established for an essential caregiver also on page 3 of the bill. The sponsor has offered a series of amendments on this bill due to some of the concerns expressed at the hearing, mostly about that if there's an executive order or any type of order that this bill would have no effect. So the sponsors offered amendments to try to deal with that and also to take care of some of the other concerns expressed during the hearing. First off, in the reprint, you'll see that there are several requests from senators to be on this bill, so that would be the First Amendment on top of the reprint. And then if you go to page 1 or page 2 of the reprint, these procedures would only be in effect during a declared state of emergency or other time when access or visitation is restricted. So that's his second change, and so these procedures would only apply during times of emergency. There's lines 28 through 31 are struck because they require the nursing program or assisted living program to consult with the local health department, and the local health department group, Macho, requested that this come out because that's a little more than they can handle in this type of circumstances. So the sponsor agreed and offered an amendment to take out that specific language. Now, if we go to page 4 of the reprint, there's new language added, and this is this gets at the testimony that if there was an emergency, none of this would apply. So what the sponsor has done is gone to the public safety article. These are the provisions that give the governor emergency powers, and it's all listed in here. However, if you go to the first page after page 4, you'll see that that particular part of the code that governs these essential caregivers would not be subject to the powers of the governor under an emergency order. So it would exempt that section of the code from the governor's powers. So these procedures for visitors by essential caregivers and assisted living programs, it would still apply regardless of what the governor does with emergency powers. So that's essentially what these two changes do to the governor's emergency powers, that they would not apply to this part of this particular part of the code. That
So when this goes to the floor, would you leave the governor's essential powers there or not? If they're not applicable?
Is it okay? I mean, there was a lot of opposition, and I'm getting some comments about that they at least like to see these amendments before we move forward.
Yeah, can I just, before we do that, we did have extensive unfavorables. Did any of these amendments, to your knowledge, adjust anybody's position on the bill? Because I'm looking through the witness list. I mean, there is a fair amount of opposition.
I don't, the industry obviously opposes this. They testified that, if the governor does issue an executive order or, issues his emergency proclamation, then, all this would be null and void anyway. However, if there's a national emergency, and so there's an emergency issued by CMS or some other national group, again, this law would not apply. So this can't affect anything from the national level. This just affects, with his amendments, would affect the governor's powers to, do whatever he has to do to address the emergency.
Okay, before we,
And if you
go
were
ahead.
the governor, he'll veto it, and then you'll be back in next year.
Senator Bottle, before we go to the hold, did you want to get some
Well,
questions out here?
My heart really goes out to folks that have a loved one in a facility and they can't visit them. During all this time, we've taken care of my 92-year-old dad and my 84-year-old uncle, who was in a lovely facility that got COVID from someone that came into the facility. And once it came in, it flew through that facility. They had 60 people with COVID, like over a 2-week period. And so, while your heart goes out to someone who needs a visitor or wants a family member, do you want to expose all those people to COVID? So I agree. I think we should hold the bill and let's work on it a little more.
Before we just go, let's, get some questions, if there is some, before we do the hold. Senator Augustine.
I just want to support what Senator Bidle has said, because I actually looked at this, putting in a piece of legislation that looked like this, and I pulled back because of a lot of the concerns that I found. And chose not to actually introduce this because of my research and finding out like there were some real problems associated with folks who were going into the home and just not being able to really control what was happening. I just wanted to share that with the committee.
Okay, we'll go to Senator Jennings, then Senator Reedy, and then we may go back to the hold.
So this is a bill that touches personally. I lost 2 family members, one from COVID, my grandmother, who was in a nursing home, and my father actually got a call basically 2 hours before she passed saying, hey, you can come in, but they suited him up in a hazmat suit in the parking lot, and he was able to go in for the last hour. But then my uncle died not from COVID, but because of COVID. Because people couldn't go in, my cousin couldn't go to see him. He was in there for 10 months. He languished. And, I trust these nursing homes and these hospitals and stuff, but without a loved one going in to see, who's checking to make sure they're all right? So, and believe me, I understand exactly what my 2 colleagues to the right have said. Worst thing we want is somebody coming in there and, I know your district, it spread right through the nursing home. But I do think there's got to be something we can do in the future to allow this, because it was horrible what people have gone through.
This is a tough issue. It's a tough issue.
And I just wanted to say that.
Senator Reedy?
Yeah, so I guess I'm sort of echoing Senator Jennings, although I agree with everything that's been said as far as it's tough because, of course, you don't want to have it spread in a facility. There also is kind of a key of, it's one thing if it's for a month or 2, but there were times where there really wasn't a good reason why somebody couldn't take a test, get suited up, and go in, but it was just very difficult because, the hospitals have to follow the letter of, the law, or in this case, the letter of an executive order. I understand we have to be real careful about what we put into these different, these different parts of the law. I don't know. I mean, I understand we're going to hold it here, but I feel like we've got to find it. But there has to be a balance between, of course, you don't want somebody to go into a nursing home and wipe out 50 people, but there is a human cost in not being able to get somebody to come in and see. My father-in-law was just in the hospital in Georgia for a couple of weeks, not about COVID, thankfully, but really his wife, my mother-in-law, wasn't really allowed to visit him, even though he was it wasn't COVID-related. And, and thankfully he wasn't in really a life-threatening, but it was pretty serious what he was in for. So it's a challenging, I wish if we could find a way. I mean, it would be really good to find a way to do this. So I don't have any solutions. I'm just saying, I want to speak up and say we can't be so afraid of COVID or anything else in the future that we don't remember the humanity of what's going on both sides, right? I mean, it's not just people being worried about COVID, but somebody who can die because they don't have the human interaction they need. And I know nobody on this committee, I'm not accusing me of this committee of forgetting anybody's humanity, but it just, sometimes it's like we go too far one way and we don't remember the other things that people need.
Madam Chair, did you wanted to?
I lost a sister to COVID in a New York hospital, and she used to be head of the New York Hospital Association. But we weren't allowed to even go into New York. We were going to be put into quarantine, and they wouldn't let us do anything more than spend 10 and 11 hours a day trying to get somebody to answer us at the nursing center in the hospital. So it's terrible, but it won't help for people from the outside to go in. I went through it. But I'm thinking what we ought to do is over our interim, think about other telephonic or some kind of modalities that we could develop for the state of Maryland. So there's a way, if you could even hear a favorite story or something that family has recorded or something that could be shared with the person when it is impractical and harmful to have them coming in and out. I think we could do something more than to do nothing and say it's either one or the other. So I think we need to do some more thinking.
Well, I'm glad we're having this is an important issue. You know, we spend time sometimes on not big issues. This is a big one. I think it's the kind of issue we should be talking about. But for now, there seems to be a will to hold the bill and think about options. So unless there's some objection, we'll hold Senate Bill 47. And now we'll go to Senator Hayes' bill, Senate Bill 107.
Okay, Senate Bill 107 deals with, it's called the Secure Maryland Wage Act. And I'll briefly describe the bill. It requires that non-exempt employees, and non-exempt would be under the Fair Labor Standards Act, so that would mostly be your wage and hour folks, requires that non-exempt employees of BWI Thurgood Marshall Airport, the Port of Baltimore, and Pennsylvania Station in Baltimore. These are called heightened security interest locations, would require employees to get paid wages and benefits at these locations that are at least equal to wages for Guard 1 classifications established by the Department of Labor. And I couldn't find the most recent Guard 1 classification established by the Department of Labor, but in the fiscal note on last year's bill for 2019, the wage was $14.27, and the health benefit, the value of the health benefits was an additional $4.22. So it's probably may have gone up a little or maybe not since 2019.
I have that number if you want it.
Okay, what's the number?
You're close. It's $14.32 with fringe benefits of $4.54 for a total of $18.86.
Okay, so it hasn't really gone up since 2019. Okay. There are notification, record keeping, and enforcement procedures by the Commissioner of Labor and Industry. Aggrieved employees may take or initiate actions, and there are remedies for these actions, similar to other labor laws in Title III of the Labor and Employment Article. Certain actions by employers and employees are prohibited, and an employer may not retaliate against an employee who exercises their rights under this act. The employees would be, these employees would also be exempt from the state wage and hour law and the state living wage law. And currently, if I might probably will get asked, the current state minimum wage is $11.75, and the current living wage for Tier 1, which would be the areas these would all fall into, is now $14.42. You have a reprint in front of you with amendments offered by Senator Hayes and Senator Beidel. The amendments are mutually exclusive, so rather than offering separate amendments, I just included everything in one reprint, and they're identified as we go through the reprint. So if you go to page 2 of the reprint, there's a series of technical amendments to the bill. This should have been subtitle 16 rather than subtitle 15. It didn't account for a vetoed bill from last year, so the drafter, who happened to be me, made a mistake there. So all of this had to be fixed throughout the bill. So you'll see these changes throughout the bill, changing everything from Title 15 to Title 16. And again, on page 3 of the amendment on top, you'll see another change to subtitle 16. In the middle of this page, this is the language that exempts people covered under the Maryland Secure Wage Act from the wage and hour law. Senator Hayes has offered an additional amendment on the bottom of the page, and this brings in the tip credit under the wage and hour law. And I don't know if some of you know, most of you know that the tip credit means that if you're a tipped employee in the state of Maryland, you get paid a base tip wage, and then as long as your tips take you above the minimum wage, the employer has no more responsibility other than to pay you for the tip credit wage, which is about $3.43 in Maryland. What this does is it exempts employees covered by the Maryland Secure Wage Act from the tip, specifically from the tip credit requirement. So they would not be tipped employees at all in the state under the wage and hour law. If you go to the next blank or unnumbered page, this brings in the start of the Secure Wage Act. And if you go to page 4 of 12, you'll see who are covered employees at the top. That means any individual employed to perform work at these heightened security interest locations who is an exempt employee from the FLSA. Senator A. Hayes has offered an additional amendment to expand on who covered employees are not. So you'll see here that a covered employee is not somebody at a retail establishment, a food service facility, or an on-airport or off-airport motor vehicle rental company or any other company involved with motor vehicle rental operations. The next amendment below that is offered by Senator Bidle, and this would say also a covered employee does not include an employee who receives wages or benefits under the terms of a collective bargaining agreement. If you go down further on the page, you'll see who an employer includes, and anybody who acts directly or indirectly in the interest of another employee. An employer, Senator Hayes has offered an additional amendment here that an employer does not include an employer that provides construction services as defined in 3901 of this title. That's the employee misclassification section. And Senator Bidle has added an additional employer does not include an airline. So if you're in construction or you're in an airline and you're an employer, you would not be covered by these laws under both proposals. Further on down, you'll see that heightened security interest location is defined as BWI, Thurgood Marshall, Pennsylvania Station, and the Port of Baltimore. At the bottom of the page, onto the next page, there are legislative findings for the act. And on the next page,
Chair Kelly.
What we have done with these amendments is to not overpay or to enhance the pay of folks that already are fairly well off, relatively speaking, in the airline, in the airport industry. And you're looking out for the little ones that don't have much support and much in terms of wages. Is that what has just happened?
well, it depends. The covered by taking out retail establishments and food service facilities and folks who work for basically the rental car companies and the people who shuttle them back and forth. You know, if you go to an airport, anybody in one of those little stores or whatever would not be covered by this act.
But they also not working for the. Yeah.
And then Senator Bidle would go. She would say that if you're under a collective bargaining act, which most of the airline employees are, then they would not be covered by this. Mm-hmm. And if you go further and say employer does not include, well, anybody who's in construction services would be out of this, and I think that has something to do with prevailing wage. Mm-hmm. And also, if you take out the airlines, well, then they would not be an employer under this article.
So, for example, the people who drive the wheelchairs and the people
who
clean
covered.
The bathrooms would be covered.
Yeah, anybody you see in an the way I can figure this out is if anybody you would see at an airport who is walking in the corridors and not in a food service facility or retail facility and doesn't have the markings of an airline on their uniform, they would be covered by this bill. So it would be the people in the hallways, the people cleaning the airplanes, the people on the tarmac putting baggage.
Essential workers. That's really what you got.
Okay, well, Senator Bottle, I know since half of these amendments are your amendments, and you've been itching, and then we'll go to Senator Jennings. But Senator Bottle, if you want to weigh in on your own amendments.
Thank you, Mr. Vice Chair. And my amendments are really very short, but we're going to take out an airline. We've come to some agreement with the sponsor, and if we take out an airline, I believe that my other amendment's going to be considered a friendly amendment. Am I correct, Mr. Sponsor?
Yeah.
Thank you.
Only addition is, where was it? An employee, so on Roman numeral 2, where it says, is an employee who receives wages or benefits under terms of a collective bargaining agreement, as of January 2020. It would be the language to add.
Okay.
Right, so and that amendment is just making sure that it doesn't prohibit anybody that may in the future come under a bargaining unit, only those individuals who are currently under a separate bargaining unit.
I guess I should point out bargaining units expire, or bargaining agreements expire. So I don't know how you would,
They're under a bargaining unit now, they would not be included. They wouldn't have an effect on the future.
Okay, why don't we just get some more discussion? Senator Jennings, and we'll go to Senator Benson. But Senator Jennings, you want to weigh in on
Can you
these
explain the
amendments?
tipped wage portion? Because my question is like a porter. This will affect porters, right?
yes. Well, if you wait, there's we're going on a little further. It's, if you exempt them from the wage and hour law completely, I'm not sure what the complete rationale for bringing in a tip credit was. That was from the sponsor, but I think it specifies that the folks who, generally the people who get tips are the porters or the people who push the wheelchairs.
Mm-hmm.
So there's an amendment that goes along with that further on in that would allow these employees to get paid the wage plus keep all their tips. So they would not be subject to the tip. They would not at all be subject to any type of tip credit provisions under the wage and hour law.
That makes sense.
Can I just ask you one technical? So with this one adjustment on the airline issues, are the Hayes and Bottle amendments in any way in conflict with each other, or they are completely?
Not conflict with
Okay.
each other. They're separate and distinct. So you're just, what you're doing with Senator Beidel's first amendment to covered employees is you just add an additional group of employees who would not be considered covered employees. And the same with employer. Senator Hayes is taking out the construction services, and Senator Beidel is now no longer, doesn't want to take out the airlines.
Okay, so
So you can take them up individually or.
okay. Well, Senator Benson wants to weigh in. Senator Benson.
So you're taking out two, Roman numeral 1, an employee that provides construction services. You say you're taking that out?
No, the construction folks are not going to be covered by this bill.
Someone needs to explain that to me.
You're taking this one off.
Are you taking out the?
Roman numeral 2 and airline.
The sponsor wants construction industry out of the bill.
And Mr. Sponsor, just again, so there's no miscommunication, so the Senator Bottle's amendments with that one modification on airlines, you perceive that as sponsor as friendly amendments now, or she said that, but I want you to represent what you think.
And so removing the airline, but putting a date as of January 2020 would be what we would want to receive as a friendly.
Okay, Council, did you get all that?
So an employee who receives wages, or Senator Beidel's new amendment would be an employee who receives wages or benefits under the terms of a collective bargaining agreement as of January 1st, 2020.
Okay, Senator Reedy, do you have questions on it in these amendments?
Yeah, no, I mean, I think I'm tracking, but why the date?
Because we know who they are.
Right, because we know who the current employees that are covered under a bargaining unit right now.
Right, does it cover though, as of, so anything beyond that
Right.
date? Moving forward prospectively, they'll be covered?
Right.
Okay.
Yeah.
Okay, any further discussion, clarification, questions about these amendments? Senator Hershey?
Yeah, I just want to make sure I understand that as well, because it's excluding an employee that is under a collective bargaining agreement as of 2020. You mean that the agreement itself has been, I guess, ratified or whatever unions do but an employee could be hired in 3 years, they'd still be exempt and not included in this, right?
Right, and we probably won't vote on this completely today. We're just going through the amendments or whatever. And I'm gonna ask that we don't vote on it completely today, especially because there's so many changes and people might want to digest this a little bit. But I want to make sure everybody's clear on what it is that we're asking. But that's the idea.
You mean
If
a
they
ratified
have an
collective
agreement in
bargaining
place
agreement?
as of January 2020,
Okay.
it wouldn't have an effect on it.
Okay, so again, we're just trying to get all the questions on the table for the next time we convene, and we'll take this up again. Senator Reedy.
So on page 6 of the reprint, line 1 through line 8, and I know so this was in the original bill, except for the amendment to 2023. I'm trying to understand what it is we're getting at and who we're getting at, and why the state has an interest in doing this, because we've exempted out. I know it's not for restaurant, it's not for retail, so who are the employees this is going to cover?
Well, as we, first off, if we can go before that, and then I'll get to who this is going to cover. If we go to page 5, there's an important little provision on lines 19 through 21. So it only applies to, you're only a covered employee if you work at least 50% of your time during the work week at this heightened security location. So if you're a part-time employee and you work somewhere else, and then you would not fall under this title. So you have to have at least 50%, over 50% of your time spent at the heightened security.
And the heightened security location, is that like security guards? I mean,
it could be a security. It could be, again, if you're not employed, well, with Senator Beidel's changes, some airline employees could possibly find themselves under this bill and be a covered employee. Only those who would be in a collective bargaining agreement would not be a covered employee. An existing collective bargaining agreement.
Yeah, I guess I'm trying to figure out who employs the people that we're now talking about.
There's contractors out there. The state has service contracts out there through the airport, probably, with a lot of the employees in the airport. Those who clean the airplanes, those who load the baggage, some security guards, not the TSA folks or the police, but some.
Because TSA is federal employees, so this doesn't cover them.
Yeah, and it couldn't affect them. But some of the security guards probably, I don't know if they're armed or not, but they're probably not. But some security guards, the folks who push the wheelchairs.
Oh, okay.
Those folks you see walking around down there, driving the carts, those folks you see who do not have who are not in a store, in a restaurant, but are in the hallways cleaning, transporting people, doing some routine maintenance in the facility. Those folks who do not have a uniform that's again, the airlines are out now. But any airline employee who's under a collective bargaining agreement would be exempt from this bill.
But the airlines may employ some of these people in this capacity.
Yes.
And then the rest of them are contractors employed by the state? Is that?
They're probably under service contracts with the state of Maryland, yes, with the airport authority.
So I think I'm seeing the picture of why we're doing it, okay, or why this bill is here. I got it, okay.
Okay, any additional questions, clarifications about all these amendments before we hold it and take it up next time? And you've got the sponsors here, so any other questions?
There's a couple other quick amendments from the sponsor before we move on to the next bill. On top of page 6, the original, they had to start getting the wage on January 1st, 2022. The sponsors proposing that date be moved out to 2023. If you go in the middle, this allows the tipped employees at the airport to get paid the wage plus keep all their tips. That's that middle language there. And the rest of the bill is not something you wouldn't see in any other part of Title III regarding labor laws. There's enforcement provisions by the commissioner, what employee can and cannot do, authorizations to initiate an action. All of this is very similar to other labor laws. And if we go to the very back of the bill, pages 11 and 12, you'll see this exempts these folks from the living wage provisions under state law and state's finance and procurement. That was done many years ago, and again, it requires people on state contracts, state service contracts to be paid a living wage. And Senator Hayes has another amendment that if the state is still under a public emergency as of September 1st, 2022, that they could be moved even further off to January 1st, 2024 before they would have to start paying the wage equivalent to the security guard's wage under federal law.
Okay, I think next time we reconvene, be prepared to vote on this bill and the amendment. Senator Model.
Thank you. This afternoon, very late, I received a letter from MDOT and MAA, and for once, they've given us an opinion. You know, we don't usually get a position, but their position is unfavorable.
On this bill.
Now, I don't know after they see the amendment, so I think we need to work with them.
Okay.
No, they asked for an unfavorable report.
Yeah.
Only better with the amendment, so we'll have to talk with them. They never give us a position any other time, but.
Yeah, okay, well, so just make a note of that. We've got some additional. Okay, guys, we're going to hold that bill till next voting session. Let's go on to Senate Bill 135, Senator Klaus Meyer's bill. David?
Okay. You heard this bill last week, and it was held. And so it's back before you. This, just to refresh your memory very quickly, this requires battery charged fence security systems to be regulated like security systems under state law. And it would take them out, it would specify that these types of fences located within another fence that has been approved by a local government, it would require that these fences will not be subject to any type of zoning or permit approval by a local government. You have a reprint in front of you, which is from Senator Augustine, and I guess I could say Senator Hayes too, that changes the bill. It allows the same definitions to go forth about what a battery charged security system is, how they work, but the amendments first change is on page 2 of 4, and it changes the description of what is zoned from a property that is not zoned as residential use to a property that is zoned for commercial or industrial use. And then it takes out all the rest of the requirements in a bill for a local government and simply says that, if you go to the very end of the reprint, that a local government shall approve or deny an application for battery charged fence security system within 9 months of receipt of a completed application. So it essentially would bring them back into the local permitting process, application and permitting process. And I should point out there's an additional amendment that I just got from Senator Klaus Meyer. The House added this amendment on the floor to the bill, and this would exempt electric fences that are meant to contain deer fencing or livestock fencing from the requirements of the bill. So the House added that on the floor, so that bill is coming over with this amendment, but this is a separate amendment on the reprint in front of you from Senator Augustine, which would basically restore local government's ability to approve these electric fences.
We'll go to Senator Augustine. Just to clarify, though, the House bill, I assume these are MACO bill, amendment of some sort.
Yeah.
The House bill that's coming our way does or does not have the MACO?
Does not have Senator Augustine's amendment. It has Senator Klaus Meyer's amendment about exempting fencing that is intended to keep deer out or livestock in.
Okay, with that said, now we know where the, Senator Augustine.
Yeah. First things, I just have a question about the bill that David keeps referring to, because I've not seen it. Can you tell me what that number is?
The bill,
on the House.
Oh yeah, there's identical bills, but they weren't listed as cross files. So that bill is House Bill 261.
Okay. Yeah. First of all, that helps. Thank you.
For some reason, when the sponsors put them in, they were not done as cross files, so our system didn't reflect that. But they're the same bill.
Okay, great. So that's the first help. The second thing is, just on this amendment, basically, we heard from these are from MML. I did go back, I talked to them about it. They were concerned about taking the local control away. But what this amendment does is it maintains local control, but it addresses the concern that the persons who brought the bill forward actually had, which is they were concerned about the amount of time that it was taking the permit process. So this, sets a clock. It says, okay, you got to do it in this period of time, but it doesn't take away the local control of this issue, which I do think is the appropriate place for it. I mean, that's the main part of this amendment.
Okay, let's go to Senator Hayes and then back to Senator Bottle. Senator Hayes, and then Senator Benson. Senator Hayes, Benson, then Bottle. Hayes,
Whose bill is this, David or Nathan?
Yeah, David.
I'm just trying to figure out which one. I know that we have several different papers. I see clearly Senator Bidel's amendment. The reprint, is this Senator Augustine's amendment?
You mean Senator Klaus? The other amendments from Senator Klaus Meyer.
Right, that's separate and apart.
Yeah, Senator
That's
Vidal doesn't have any amendments to this bill.
I'm
So
sorry?
this is all, the reprint you have for 135 in front
It's
of you.
all
is Senator
Senator Augustine's
It's all-
MML amendment.
Yes, the MML amendment from Senator Augustine.
Okay, all right. I thought you said we did not have, I misheard you. Thank you.
Okay, Senator Benson, and then we'll go to Senator Bottle.
I just wanted to ask when they did the testimony, they were very concerned about the time frame. I see here on page number 4, it says local government shall approve, blah, 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 9 months or receipt of a completed application. Weren't they concerned about the time frame? Why would it take 9 months? I guess they were thinking about people having a baby.
Okay, Senator Klausmeyer, well,
Yeah.
Senator Bidle, and then back to Senator Klausmeyer. Let's go in order.
What's Senator Klausmeyer's bill?
Okay.
Agree.
We have 9 months here.
Well, you got it, the maker of the amendment, I don't know what to tell you.
And as I said when I talked about this earlier, the 8 municipalities that I represent, of the 27 that are in Prince George's County, don't like this bill at all, first of all, because they're trying to take away the local control from where it belongs. This is land use planning. We don't do that up here. But okay, so you guys want to do that? You want to go down into what is local authority. That's what they want to do. So what this amendment that MML is coming up with is saying, we understand that. Let's put a time certain on there that we have to respond. Now, if y'all want to talk about maybe that needs to be changed, the time needs to be changed, I can understand that. But what we're trying to do is maintain the control at the local level instead of getting the control up here. And that's what that's about.
Okay,
I understand that, Senator. The thing that I was concerned about is why would an application such as what they're asking for, why would it take 9 months?
Well, shit, man.
We could probably talk about that part, but the idea is still to maintain the local control.
Okay,
Okay.
thank you very much.
Senator-
I understand.
before we go back to Senator Bottle, Senator Klausmeyer, you wanted to make a quick
No,
comment?
I just want to follow up with what Senator Benson said. The reason the bill is here is because sometimes it takes 9 months or a year just to put this thing up. And it's behind the other fence, and it's just taking way, way too long. So that is why the bill is here. And if we don't pass the bill, life will go on the same way it is now, 9 months to a year to a year and a half just to get this fence up. In the meantime, somebody's losing lots of their equity out in the parking lot because people are stealing stuff from them and everything else.
Okay, Senator Bottle, did you want to weigh in on this?
I thank Senator Augustine for finding a way not to take away the rights of the county and local municipalities, but I agree with Senator Klausmeyer. 9 months is too long. This is not a construction. They're not constructing a facility. So I'd like to just see a shorter amount of time, maybe
Okay.
3 months.
Okay, Senator Hayes, I mean, if there is a desire to focus on that part of it, I mean, let's get some consensus if we want to vote on the bill or we want to hold it to talk about a reduced time frame. Senator Hayes.
I think the compelling testimony for me during the hearing was the fact that it's not the main fence, right? And so what was explained to us several times, this is a security feature in addition to the main fence that would be exposed to the property owner. And I agree that 9 months is ridiculously too long, or whatever. But it sounds like they've tried to reach, and I'm the blame. Last week I asked to hold this bill to this week because I know MACO and MML had amendments, but I'm just not sure if the amendments presented to us are in good faith. It seemed like just another way to, gut or delay the bill. It doesn't really seem like they've really given any thought to it, and just using this amendment as a way to hold on to it. So I'm not feeling this amendment.
Okay, Chair Kelly.
It occurred to me maybe about 120 days. That way, no matter what the commissions that have to do the voting and the deciding have as their regular time and how much stuff they've got on their agenda, they could probably get around to at least 2 meetings and an observation period of the circumstances. So I would just suggest instead of so much time, let's make it 120
Okay, Senator Jennings.
So the way I read this is for the permit. Let's say I have a piece of property and I decide I need one of these fences. I go into the permit office and say, hey, I want to get this fence up. I think no more than 30 days. You submit your proposal, your blueprints, your drawings, you make sure everything's right, you give it to them, and to me, 30 days. I mean, this is like getting a shed permit or anything else you're going to do, and they don't go anywhere over that time. So 30 days to me.
The thing to remember, though, is that you are dealing with another level of government, and part of the holdup here is they are trying to protect their prerogatives. And I think once it's in place, we could come back later to when they're used to this happening and the world doesn't fall in,
Okay, sponsor of the bill, Senator Klaus Meyer.
Yes. But we've been dealing with this bill for 2 years now, and it was all ready to go last week, and somebody pulled out the amendment. But the fact of the matter is, it's going back at just what JB said, 30 days, and then the inspector comes, and if it's not right, then they can't turn it on. And that's the way it's just crazy that we have to wait for 9 months to put a fence up that's behind another fence.
I sometimes say, though, to have some progress. And sometimes when people get used to something, it isn't all that terrible, then you could bring it down. Let's ask for 90 days. That way, they may want the governing body to vote on a recommendation from the person in the permit office. Give them enough time to meet.
What? Okay, well, before we got people still want to weigh in on the amendment, so Senator Hayes and then Senator Reedy, and then we're going to have to come to some consensus about how we want to proceed here. Senator Hayes and then Senator Reedy.
Thank you, Mr. Vice Chair. So from council, there's been talk about, I'm not a big fan of the amendment, but we talked about 30 days, 60 days, 90 days. So say a local government don't approve the application within 30 days, 60 days, 90 days, whatever. What is the recourse? Does that then grant the ability to go ahead and do the fence absent them?
No, but I did hear from the representative of the sponsor that they would accept the kind of plan that is being offered by Senator Augustine.
Okay.
They think that's preferable to right now when they can't do anything.
Right.
And I think once it's in place and it's in there for a while, and they'll pay a permit fee to even get the inspection and everything, it probably in 2 or 3 years could be brought down some. But maybe if we ask for
I get it. I guess my question is a little bit different. I'm trying to understand, like, if we was to make that change in the time frame, like, what is the recourse to the individual that's requesting the fence? If say we say 30 days, right? Say we agree to 30 days.
No, we changed from 30.
Whatever. Say we say 50 days. I don't know. Let me meet you in the middle. Say we say 50 days, and whatever local government has failed to deny or accept the application. What happened? Can I build my fence?
And this is a state law, and the state law is silent on that, so it's unclear what would be the next steps if the local government did not make it within the 9 months of receiving a completed application. So you don't have anything in here, so it's not clear what the next steps would be for the business.
It did sound like, it does seem to me, however, that what they are doing is person that they should have prerogatives. They're the local government. And I'm saying, go on and put a reasonable time on it now. I wouldn't go as low as 30. I'd take it a little bit higher so they've got time if they want the permit office to report to them at a meeting that the county council has or somebody else has. They've got time to act.
Okay, how about we do this? Everybody gets one more shot, and then we'll make some committee decision about how to proceed forward. I'm going to go in the order I saw the lights. So it's Hershey, Reedy, Augustine, and then Kramer, and then maybe back to Hayes. And then let's come to some consensus here, because we could spend all night talking about this. Okay, Senator Hershey, you're up.
Thank you. I would generally always agree with my colleague about local authority by all stretches with what we're doing. But at some point in time, it has to transfer from local zoning authority to personal property and the rights of businesses to be able to protect their inventory and their equipment and things where you're generally going to see this type of fence. In my opinion, the fact that the county has already approved the perimeter fence on the outside says that they were okay with the fence. Now, inside of that fence, which they've already approved, now we're on to the personal property of the business. They're asking to erect just the taller fence. Okay? So that way, to me, that means that the jurisdiction that is reviewing this has approved something, and unfortunately, the reason why the bill is here is because this process has taken so long because they're unfamiliar with the product. They're unfamiliar with what this fence does, and that's why they're delaying the process, and that's why they've asked for our help on this. And so that's why I would resist that amendment and go with the bill as it's been written. The other thing, just to warn everybody, when we talk about these arbitrary numbers on what feels good with, whether it's 9 months or 30 days, let me assure you that permitting offices know that date exactly. So if we say 30 days and it doesn't get done, on the 29th day, they will reject that application. And that's what I want to prevent from happening. That would actually make this bill even worse, is if we pick the wrong date and all these permit offices just start saying, geez, 59th day, I got 60 days, I haven't had a time to take a look at it, I'm too busy, reject, and it goes out. So this bill needs some work still.
Okay, we're going to go to Reedy, Augustine, and then Kramer, and then some kind of decision is going to have to be made. So Senator Reedy.
Well, I can't improve much on what Senator Hershey just said, except I want to hammer home one point that he made and maybe make a second point. Number one, this is new technology. I think the reason there's been a holdup is in these local governments because there's like paralysis by analysis, and they can't get off the mark and make a decision in some cases. And so I think what we're doing with this bill, which I support and I like, is just taking the decision for them, helping them understand what it is and taking the decision for them. Normally, I'm somebody who never really wants to violate any local control. But, I sat here for 4 years, my first 4 years here, and we did Plan Maryland, and we did all kinds of stuff. And said, we did tier mapping. We said you can't build houses on, more than 5 houses on septic. I mean, we did all kinds of, we were doing all kinds of crazy stuff in this General Assembly, and that was several years ago. So, color me a little bit skeptical that this is going to be that significant or be that dangerous to local control. I agree it's on private property. I think Senator Hershey made great points too about not wanting to put the wrong number of days in, because there's definitely that issue too. So I don't know that really helps us with the dilemma we're in. I think the bill's fine as it is, but that's just me.
Okay, Senator Augustine, and then we'll go to Kramer.
Okay, thank you. First of all, this is not new technology. Like, as you can see from what was coming from the other folks, when you got to take out deer fencing and livestock fencing, it's an electric fence, y'all. I mean, that's what it is, right? And what they're asking for is local to be able to put this fence in, which is taller and is visual. It does have to do this. So I'm surprised that you guys are okay with that. The next thing on that, the next thing will be, okay, so they put a fence on the outside, so if you're going to have a deck done on the inside, we don't need a permit for that either because it's on the inside. I'm just saying that's, to me, is the approach that you guys are taking with this to imply. Now the next thing, do we not have to do the electrical? Do the locals not to get a chance to get to do that either because you got something on the exterior? This is where I'm coming from. I think that, listen, a lower number, like was suggested, the chair said like 90 days or something like that. If you guys could work with that, think that that could work with folks. I just think that that's a better solution than just absolutely taking away this local control. And that's it. I'm sorry.
Okay, no.
See what would happen if it's okay, I'd like to move 90 days.
Okay, well, before we do that, Senator Kramer had, I guess, the final word, and then we'll. Oh, I'm sorry, I can't see you over there. Senator Klaus, Meyer, then Senator Kramer. Sorry.
It's only a 12-volt battery, and the woman who showed us, she said if you touch it, it's probably like a shock collar on a dog. And it's not an electric fence. It's a 12-volt battery, period.
Okay, Senator Kramer.
Yeah, I think what concerns me was addressed by Senator Hershey, and that is whatever period of time, no matter how arbitrary we are, 30 days, 60 days, and I agree, 60 days would be more than enough time. The problem's going to be day 59, they're going to just deny it if we have, for instance, a default. So let's say, in response to Senator Hayes' question, if it is not approved within 60 days, they can move forward with construction of the fence. That would be the default. But the problem's going to be the permitting services in these jurisdictions are going to look at that and go, okay, we've denied it, and then the process starts all over again with a new application because that's how this is going to play out in the real world. So I'm not sure that we can put in place a time. I think we either adopt the amendment or we reject the amendment, but I don't think putting in a period in which it has to be approved is going to accomplish anything, because I can see all the local permitting services simply, denying the application if we put in a default that they can move forward if the, local jurisdiction has not responded. So I don't see the benefit to putting in a date certain by which this has to be accomplished.
Okay, so we clearly have something of a split here in the committee. We do have an amendment that I assume it was modified to go from 9 months to 90 days. Now, the question, does the move-in of the amendment and the movement sponsor of the original amendment want to press that? Or do we want to have some backroom conversations about possible additional compromise? I mean, let's,
I think there's so many important bills that we don't want to take forever on this, but why don't we vote on something and see if it's reasonable to our colleagues on the floor?
Well,
I'd say 90 days, and if nothing happens, then...
Okay, well, Madam Chair, yeah.
90 days, it's on there. Can we vote on it?
Okay, so we have, so guys, just pay attention. We've got an amendment on the table to take that 9 months, reduce it to 90 days. We had a motion favorable on that in a second. So yes, Senator Kramer.
Yeah, my question is, so don't we have an amendment before us already?
It
that
wasn't
has to
offered,
be-
it was just in the reprint, I think. I don't think it was a formal move. The
Oh,
9
so
month,
we don't have an amendment before us. And so where did the change back to the 9 months?
no, that's in the reprint. It's an offered amendment, but it wasn't moved by anybody. It's just for purposes of discussion, the reprint. Those are MML amendments in the reprint.
Okay, so we have no amendment before us at the
Well,
moment.
no, we now have an amendment.
All right,
We have
well,
an amendment
no,
from, yes.
Please allow me to finish.
Well, you can finish.
Okay, just let me finish.
Sure.
It says now, local government shall approve or deny an application for battery charged fence security system within 9 months of receipt of a completed application. Is that language from the original bill?
No, that's the Augustine amendment
Okay.
that hasn't been
So
moved.
then there is something that we are looking to do to amend the bill, not taking up the Augustine amendment, but is not in the bill now.
Correct.
So you're looking to disregard that language and add language that would amend the bill, creating a date certain.
That's what the
Okay.
amendment proffered by Senator Kelly and seconded by Senator Augustine does.
We don't adopt the rest of the Augustine
Okay,
amendments.
so let's be clear about this, council.
If I'm following this, all you're gonna alter Senator Augustine's amendment, everything involved with it, and just say, instead of 9 months, 90 days. So the rest of the amendment is still, you're altering Senator Augustine's amendment, which,
We were just told we don't have the Augustine amendment on the table.
No,
This now is the Kelly amendment, which he seconded.
the Kelly amendment simply takes the 90, it is this reprint, instead of nine months, it's 90 days. That's the amendment that's being offered. But otherwise, it is the reprint.
Which is the Augustine amendment.
Well, it's not now the Augustine amendment, it's the Kelly amendment.
So we've got an amendment to the amendment. And my point is, don't you have to adopt an amendment in order to amend an amendment?
No,
at that point?
there was never, the Augustine amendment was never moved. So it's just in this reprint. It's not in front of us.
But the reprint's an amendment.
It's not an amendment. A reprint's a reprint. Until somebody moves the amendment, there's nothing in front of the committee.
I think the amendment now, it would be the Augustine amendment modified by the chair.
Well,
Because that's what you're saying, right? That's my point. Right, that's what it has to be, because we need, it's not just an amendment that says 90 days. Correct. It's his entire amendment modified to say
Okay,
90 days instead of 9 months.
I assume that
Correct.
everybody understood that. It is, if I can be clear again, the reprint has changes to the bill. The modification proffered by Senator Kelly is to change what's in the reprint. So yes, it is the language of the Augustine amendment, but it's now the Kelly amendment with the 90 days instead of the 9 months. I don't know how much clearer we can be. Seconded by Augustine, but it's the Kelly amendment, not the Augustine amendment. So we have that, and this is one where I think we're going to have to take a roll call. So everybody knows what they're voting on now, right?
Yeah.
Okay. Somebody's going to have to take the call there, Tammy.
Okay. Senator Feldman,
Okay, I'm going to go no on the amendment.
Senator Klaus Meyer,
No.
Senator Benson.
Yep.
Senator Hayes.
Whoa.
I'm sorry.
Am I in a timeout?
Sorry. Senator Kramer,
No.
Senator Hayes.
No.
Senator Reedy.
No.
Senator Augustine.
yes.
Senator Beidel.
Yes.
Senator Hershey.
No.
Senator Jennings.
No.
Okay, the amendment fails. Any other additional amendments?
you have another amendment from Senator Klaus, which was added by the House on House Bill 261 on the floor, and this would take out deer or any type of electric fence, deer fencing or livestock fencing. So Any electric fence that keeps deer out and livestock in would be exempt from the provisions of the bill.
Okay, this was what was adopted in the House?
It was adopted on the floor of the House. And
Okay.
so that will be coming over to this committee soon.
Okay, Senator Augustine.
I mean, to be like the smart aleck, but why in the world would this, whoa, whoa! But why would this be necessary if this is some unique product and all the things that were suggested? Why does it need to talk about deer fencing and livestock fencing? Just asking the body.
Okay, Senator Jennings wants to speak to the amendment. Things are getting wild in the voting session of the Senate Finance Committee. See, teamwork, that's good. I like to see that.
It's time we should go home.
Okay, Senator Jennings.
I'm just saying, for livestock fence, there's zero permitting. It's agriculture. You just go buy your fence, put it up. There's no laws to follow at all. No setbacks, no requirements at all.
So the question would be, that being the case, why do we need this amendment? Yeah.
You want to just wait and decide how to vote when the House bill gets to the floor?
Okay, any additional discussion about the amendment of dealing with the cattle and the livestock? Okay, Senator Klaus.
I just, if this is going to screw this up and not get us moving forward, I'll take the amendment off. I withdraw the amendment until and then when it comes over from the House will have one, and we can find out why it got on there.
Okay, the sponsor of the amendment has withdrawn her amendment, it sounds like. So now we've got just the bill on the table as is. We'll take a roll call. Tammy?
Senator Klaus Meyer.
Yes.
Senator Benson.
Yep.
This
Senator
is
Kramer.
on the amendment?
No.
No.
There are
On
no
the bill
amendments.
clean?
This is the bill. Clean bill.
Yes.
Senator Hayes.
Yes.
Senator Reedy.
Yes.
Senator Augustine.
No.
Senator Beidel.
Yes.
Senator Hershey.
Yes.
Senator Jennings.
Yes.
Madam Chair.
Okay, yes.
Okay. Bill carries. Okay, so we got final page here. We want to jam through. Do you want to get through all the rest of the bills on here? Okay. Okay, Senator Lee, next bill, David. Final page, Senate Bill 158.
Okay, Senate Bill 158. Under current law, an employee is entitled to 2 hours of paid leave.
Everybody quiet. Let Dave talk.
Under current law, an employee is entitled to 2 hours of paid leave to vote on Election Day. The bill in front of you has amendments. It strikes that current authorization and will say instead, in the reprint on page 2, if on a day that an employee chooses to vote in person in an election, the employee does not have 2 hours of continuous off-duty time during that time, and the polls are open, the employer shall allow the employee to be absent work for a period of not exceeding 2 hours. Again, this would be paid leave. It also provides that an employer may not discriminate or no retaliation against an employee for exercising their rights under this act.
Okay, wait. So we got Senator Chair Kelly and then Senator Hershey.
My question is, considering now you can go to the drop box, you can vote, you can do early voting on several days at the polling place. You've got so many choices now. This doesn't make sense for any small business to be having to pay for somebody to take off on election day.
I would agree with Madam Chair.
Senator Hershey, that was you adopt.
I couldn't have said it better. I agree with the chairwoman on that.
Okay. Any addition, Senator Kramer?
Yeah, I'm up, if I recall correctly, and I had, you know what, I think I lost the bill on my iPad. The bill relates to updating current law so that someone that does not have 2 consecutive hours scheduled, so that, in other words, we've got a lot of folks who are working multiple jobs now. And this provides those people who have multiple jobs who don't necessarily have that opportunity to take off at early voting between this hour and that hour to then be able to vote when they get off of work. This gives them that opportunity to do what by law is allowed now on election day. It simply is affording that opportunity to do it during early voting, if that's when they have that opportunity, because otherwise they may not. So I think it's just recognizing.
Days that you can vote from early in the morning till it's night. You can go to a drop box. You can go on election day. You can do it by mail. You can do it by email. You've got so many options now that this really is obsolete.
Okay,
Well, then,
okay.
in current law, we permit it on election day, and this extends it to giving the same theory to individuals to be able to get out and vote during early voting if they don't have that opportunity. Now, look, I put in bills to allow vote by mail. And then I would say, I agree with you, everybody's getting mailed a ballot. But that bill hasn't passed, and it's not going to pass.
But you can do the drop box. You can do so many things now. No business should have to worry about your having to time. I think Maryland is in pretty good stance now. With all the options, you can go on Sunday, you can go on Saturday, you can go anytime you want.
And Madam Chair, a lot of folks, working folks are out there, and they have to work on Saturday and they have to work on Sunday just to put food on the table.
I think there are a lot of ways we need to accommodate the public. But here, I think we need to think about small business people and governmental agencies that need staff because you have so many options.
Okay, Senator Hayes.
Question, is this the whole bill?
This is the whole bill, yes.
All right, so what if there's a situation like Senator Kramer explained, and you have 2 or 3 jobs? Does this apply to each of those employees?
If you were to take off for the 2 hours on election day, you might find you can't get inside.
Right, but how
guaranteeing anything? They've got more options right now with
right,
all the.
but if I'm an employer, how do I know that the employee didn't take their 2 hours at one of the other jobs that they have?
There is language here that would require an employer to furnish to an employee in a timely manner proof that the employee had voted or attempted to vote. That's about the only recourse in here.
Okay, anybody else want to weigh in on this piece of legislation? Does anybody move the bill?
I move favorably. Don't know if there's a second, but.
Is there a second on this bill? I didn't hear a second. Okay, I think the bill fails for failure of a second on the Kramer favorable. Next bill is Senate Bill 913, Senator Mccray.
Okay, this is the last of my supposed bills that generate discussion. Senate Bill 913 concerns the SNAP program, Supplemental Nutritional Assistance Program, which used to be known as food stamps, and it adds a heat and eat component to the SNAP program. If a person is eligible for SNAP and receives energy assistance under LIHEAP, the bill ups the standard utility allowance for determining SNAP benefits using LIHEAP funds, thereby increasing SNAP benefits available to that household. There's an amendment offered by the sponsor, which adds a study, and you'll see that on the reprint on page 2 at the bottom, that the Department of Human Services shall study the feasibility of establishing automatic eligibility and approval for a household to participate in the MEAP program if the household is receiving SNAP benefits under state and federal law. This bill is also moved out of the Appropriations Committee as an on third reader with this amendment in the House.
Okay, any discussion? Okay, so we have an amendments on the table. Any discussion before we, anybody want to move the amendments? The Mccray amendments? We got a move ant. Any second on the? Okay, we got a move favorable and a second on the amendments from the sponsor. Any discussion? Okay, all in favor, say aye. Okay, I see some hands. Amendment carries. Anybody want to move the bill as amended? Favorable?
Move favorable.
Do I see a second? I'll second. Okay. Okay, we've got on the table, we've got Senate Bill 913, favorable with amendments. All in favor, raise your hand. All opposed, seeing none, the bill carries unanimously. Next bill, Senate Bill 5 from Senator Griffith. Nathan.
Senate Bill 5 requires applicants for the renewal of certain health occupation licenses or certificates to attest to completing an approved implicit bias training program after a certain date. The bill also requires the governor to include a certain amount of funding in the annual budget for the Office of Minority Health and Health Disparities. Finally, the bill requires the office to publish certain data on its website. There's a reprint before you that reflects 3 changes from the sponsor. The first, on page 2, adds dementia to the list of information included on a certain health report card. The second change, also on page 2, corrects an error, changing the mandated appropriation from 1.2% to 0.12% of the total funds appropriated to the Department of Health. That percentage reflects its current appropriation. The third change can be found on page 6, delays the applicability of the requirement to undergo the bill's required training to April 1st, 2022. The reprint reflects a combination of these amendments, and this package of amendments was developed in conjunction with the House.
Okay, any discussion? Anyone want to move the amendments? Senator Kelly?
Yeah, I'll move the amendments.
Okay, a second? Okay, Senator Reedy, discussion about the amendments. Okay. All in favor of the, I'm sorry? Sure. Anybody on the committee want to be a sponsor of this legislation? Yeah. Why don't you raise your hand if you want to be a sponsor of this legislation? Dave, you taking notes? Or, I mean, Nathan, I'm sorry. Sure. Okay. Okay, and Senator Kelly. Okay, and Senator Bidle. Okay. We're just on the amendments. So all in favor of the amendments, raise your hand. All opposed? Okay, the amendment carries. Now we've got on the table, is there a motion before we get to discussion? Senator Kelly's moved. Any second? Senator Augustine. Okay, Senator Reedy, we have on the table Senate Bill 5, favorable with amendments.
Okay, thank you, Mr. Chair, Mr. Vice Chair. So I'm just looking through the fiscal note again because it was a while ago we had this hearing. So this is going to mandate, it's $1.7 million. It says a year, but that's not correct, right? It's going to, these trainings are going to be about $300,000 a year. No, it goes up. It's going to keep going up. I'm looking at the fiscal note at the money that it rises. Is that all for training, or is that also because there has to be this report? I'm just trying to understand. It was a while ago when we had the hearing.
So
It's all
no.
making public changes that are going to really expand the economy and make it better and fairer for everybody.
So the primary driver of the increase in cost is this. The bill, as amended, specifies that the governor's budget must include 0.012% of the total amount of funds that are appropriated to the Department of Health for the office. The $1.788 million is the current appropriation, which equals 0.012%. So this increase in funding just is based on the increase in the total appropriation to the Department of Health historically. So I think if we look in the back of the fiscal and policy note, under state expenditures, mandated appropriation, that's the bottom of page 3.
Okay.
It goes into a bit more detail about this. Fiscal 2021 allowance for the office is $1.788 million. Moving on to page 5, it equates to 0.012%. The governor's proposed budget for fiscal 2022 includes $1.655 million.
Okay, so it's basically making sure it's requiring that the Office of Minority Health and Health Disparities get at least 1.7 million or 1.2% of the total funds appropriated MDH. Okay.
Correct.
And then the fiscal note rise is for the cost of, that's for the mandated appropriation, or is that for the cost of these training seminars? For the whole thing, is what you're telling me.
Yes, for the whole thing. I'm looking at the.
I would just say when you.
I guess I'm just confused about what the $1.8 million is when the fiscal note says only $300,000 and then $375.
Because it takes into account the governor's current appropriation.
Okay. So it's
So
just
that's
a
the
little bit of
difference.
growth. It's not the full. All right, then secondly, does this bill, I feel like I'm reading this bill and it's saying any applicant for a license is going to need to undergo implicit bias training?
The applicant for the renewal of a license or certificate issued by a health occupations board.
So anybody going for a health occupation, so if they're a nurse anesthetist, or if they're a podiatrist, or if they're we're going to require that they have to undergo training for implicit bias.
That's just one.
Yes.
So we're
piece of
convicting
a
everybody
broader-
of implicit bias before, so we're basically, by this, we're saying everybody may or likely has some kind of implicit bias.
If you think that the whole bill is doing nothing but this, it is trying to make it fairer for all kinds of people in Maryland who right now often essential workers making almost nothing, and they have the worst working conditions right now. They're the ones most exposed to COVID, and are usually grossly underpaid and don't have a way up into higher levels of society. This is just kind of an example of the kinds of things that will be needed. It would take us an encyclopedia to put down all of what's needed.
All right.
To
Well, I mean,
make
respectfully,
things fairer.
this is not. I'm concerned about people working for long hours for low wages as well, but I think this is more about people who are getting their license renewed to be a dental hygienist or a nurse anesthetist and they've got to go through a training program. So I know that's not the whole bill. I know there's other things in the bill may be fine, and certainly dealing with health disparities is important. But I'm not sure. Well, I think I made my point. I just wanted to be sure I understood the bill.
This pandemic, the people who have higher wages and who often are favored by our current systems just because of their demographic placement in the society they're having safety compared to the folks who must drive the buses, work in the jails, do the hard work that is absolutely essential for the rest of us to get along. And they don't have the same consideration, the same job training, the same opportunities, the same opportunity to move up the ladder.
Well, yeah, but that's true of there's many different groups of people that are in that situation, though. I mean,
right. And so it isn't all, when it says minority, there are all kinds of minorities. It isn't about any one group.
Okay.
There are a lot of people.
Why don't we go to Senator Augustine, then Senator Hershey. Senator Augustine.
Yeah, no, thank you. I just wanted to just say that is exactly what this bill does. We all have our implicit bias, all of us. And the attempt of this is to bring a consciousness to everyone in the hopes of really just giving everybody a fair chance and everybody being treated fairly. And I think that it is very appropriate for us to do that, particularly given all that we see, all of the evidence. It's just very clear evidence that, we all have this implicit bias. It's pervasive, and I very much support us trying to do something to address it for all of us. I mean, this is for everyone, and that's the reason why I think this is a very important bill.
Okay, Senator Hershey.
Thank you. I agree with my colleague right there. This committee has done a great job, I think, in the last number of years in trying to make sure everybody gets the appropriate health care out there. We have probably made some decisions that might have been a little bit more on the expensive side, but we've always agreed, especially primary care physicians and things of that nature, is we want to see people with health care and be able to get healthy or diagnose and understand things earlier in life that will drive down future health care costs. So I think at the same time, some of the information that we've seen from this pandemic is really what this is all about, and has actually put a spotlight on this. So I think with the amendments, I think this is a very good bill.
Okay, so we've got the bill on the table, Senate Bill 5. We've got a favorable. I think since there's been a little pushback, let's do a roll call. Tammy, let's do the roll call on this one.
Senator Feldman.
Aye.
Senator Klaus Meyer.
Yes.
Senator Benson.
Aye.
Senator Kramer.
Yes.
Senator Hayes.
Yeah.
Senator Reedy.
No.
Senator Augustine.
Yes.
Senator Beidel.
Yes.
Senator Hershey.
Yes.
Senator Jennings.
Yes.
Madam Chair.
Yes.
Senate Bill 5 passes. Two more bills on the desk here. Senate Bill, next bill, the next to the last bill, Senate Bill 466. Nathan?
Senate Bill 466 authorizes a licensed certified social worker clinical, or LCSW, in conjunction with a physician to certify an individual for involuntary admission to a facility or a VA hospital. The sponsor of the bill has offered two amendments that are reflected in the reprint with you. Beginning on page 1. Sorry? Oh, okay. Beginning on page 1 of the reprint, that provision expands the bill to apply to the admission of a minor to a facility. Number 2 adds in response to written testimony received, one physician and one licensed clinical professional counselor to the list of individuals who can sign the certificate, treating LCPCs the same as LCSWs in the bill as it was originally introduced. For context, licensing requirements for LCSWs and LCPCs at the master's degree level both require a minimum of 3,000 hours of supervised clinical experience, among many other requirements, but they're similar in terms of at least that one metric.
Do we have a reprint or anything like that? Or, okay.
Yes, Senate Bill 466.
Okay. Any discussion before we take up the amendments?
It's a good bill, and I think this makes it more feasible.
Okay. You move the amendments? Okay, a second. Okay, all in favor of the amendments on Senate Bill 466? Raise your hand. All opposed? Amendments carry. Anybody want to move the bill?
So moved.
Okay, Chair Kelly moved the bill. Senator Augustine second. All in favor of Senate Bill 466, show your hand. Okay, anybody opposed? Seeing none, bill carries. Final bill of the day, Senate Bill 503. Senator Smith, Nathan.
Senate Bill 503 requires gas service regulators to be installed or relocated outside of specific structures subject to certain requirements and exemptions. There's a reprint in front of you that reflects the amendments to the bill as it passed the House. Under the bill as amended, the gas companies must file a certain plan with the PSC by January 1, 2022, and by January and the PSC needs to issue a final order approving or disapproving of the gas company's plan after considering certain factors outlined on page 3 of the reprint. The Commission may exempt a gas service regulator from the bill's requirements after considering certain factors, including whether the company has made every reasonable effort to address factors contributing to a delay in relocating the regulators, and has committed to a reasonable implementation timeline that does not unduly cause harm. There was no opposition to the bill at the hearing.
Both of the recent explosions in Baltimore City, where there was loss of property and in one case loss of life, both involved regulators that were not outside the way they should have been. They were
Okay,
inside
so
the
we got amendments from Kramer, second from Hayes. All in favor of the amendments, raise your hand. Anybody want to move the bill? Okay. Okay, we got a Kramer movement, and we've got Bottle second. No, we got a Hayes second. No, Bottle second. All in favor of the bill as amended, raise your hand. All opposed? Bill carries. That concludes the 20 bills that this Senate Finance Committee moved its way through today. And with that, Madam Chair, I'll turn it back to you for any final announcements before adjournment.
I wouldn't dare make any more announcements tonight unless you guys tell me there's something that's absolutely essential. Thanks for working so hard.